Further hearing in the appeal of El-Husseiny and another against Invest Bank PSC.
Mr. McGrath.
Good morning, my lord. Good morning.
Good morning.
My lady, can I begin by hoping to address your questions at the end of yesterday, and in particular how a creditor of a debtor shareholder might be able to reach through to the assets of a company or similar sort of structure. And I indicated yesterday that they'd be able to obtain a charging order over the shares and take possession of the shares. And I'll go through an example from a case just very briefly to illustrate the point, if that's helpful. And then, as the shareholder, there would be two options available to them. One would be to use those powers to procure a dividend in specie of the asset.
So they get a charging order on the shares, the debtor doesn't pay, they then enforce the charge by getting hold of the shares.
Exactly, my lady.
And they can then cause the company to declare the dividend in specie.
Absolutely, or wind it up and have the assets of the company distributed. And there should be, before your ladyship and my lords, a copy of a case, Commercial Bank of Dubai and El-Husseiny. And I only bring it today, my friend has a copy, for a couple of paragraphs to illustrate this process. Have you got them? I do apologise, I don't believe they've been handed up. Can we get them handed up?
I don't think it's come to us electronically.
I do apologise, my lord. Can we rectify that post the hearing, but use the hard copy just to,
of course,
keep things moving? Whilst they're being handed out, can I just give the very basic background so we know what we're talking about? The bank here obtained a judgment in Sharjah against various defendants called the El-Husseynys. And those El-Husseiny defendants owned some BVI companies. Those BVI companies owned valuable London property. A claim was commenced in the BVI to enforce the Sharjah judgment there. And I believe the process is similar to our common law enforcement process of a foreign judgment. The BVI judgment was obtained, so therefore the Sharjah judgment became a BVI judgment for those purposes. A charging order was granted over the Al-Sari shares in the BVI companies, and to protect the assets of the BVI companies, a receiver was appointed over the BVI companies. The judgment debt was still not paid, so an order for sale under the charging order was made, and the deal struck was that the bank would obtain the Al-Shari shares in the BVI companies at a price of 9 million off the judgment debt, which was the estimated value of those companies.
9 million somethings.
£9 million, sorry. The precise figure doesn't really matter for these purposes.
So the judgment debt was diminished by the value of the BVI shares?
Exactly, my lady. And that value was measured by what the companies were said to be worth. So at this point, they have got they've got hold of the shares over the companies which own the properties, and therefore they seek possession proceedings in this jurisdiction against the properties. Now that's where one can sort of end the story. The actual judgment deals with a related claim that other people have been involved in trying to interfere with the enforcement process. But it contains just several paragraphs which very succinctly by Mr. Justice Bright show what I've just indicated, and they are paragraphs 18 to 27. And if I could ask my lady and my lords to just cast your eye on those short paragraphs 18 to 27.
I see. So the receiver sells the shares in the companies to the
Judgment debtor.
judgment debtor.
Creditor.
To the judgment creditor. Yeah.
As is prefaced at the end of 27, there's a great deal of obstacles further to overcome to get hold of these properties, with more, if I can use the language, shenanigans going on by the original judgment debtors, so it's alleged, to put obstacles in the way. But we needn't trouble ourselves as to how someone can face obstacles in the way of possession proceedings. But what one gets from this, my lady, is a very good example that those properties in London wouldn't be susceptible to a 423 claim if my friend's case was correct, whereas they're plainly assets that would be within reach of the creditors, as that set pattern of facts show. And plainly, any untoward dealings with those properties would impact the ability of a creditor to get their hands on those properties. And I know my friend made the point, and I don't in general disagree with it, that one shouldn't say that the freezing order sits exactly in the same parameters as the 423. But they are looking to do similar things in that the freezing order is at least attempting to hold the ring and prevent conduct which would prejudice a creditor, whilst then you must pursue whatever claim and enforcement one might have. So it's not exactly the same, but they are looking to do similar things, namely protecting the enforcement process, as the Privy Council was keen to emphasise most recently in the Convoy and Broad Idea case. My lady, so that's the way it's worked. VTB and Skurikin was an example of that, but in a slightly more a different context. It was a Liechtenstein Foundation. One knows you're always in trouble when there's a Liechtenstein Foundation involved. And VTB, the bank, there was seeking to enforce its various judgments. It had more than one that had obtained against Mr. Skurikin. The Liechtenstein Foundation held membership interests in a UK limited liability partnership called Pikewell. Pikewell, in turn, owned various valuable properties. The Liechtenstein law evidence and factual evidence made it clear how foundations operate, and typically via a mandate from the person who set it up, the settlor or founder, and almost universally that mandate is oral in nature. which can make finding out who's ultimately pulling the strings an extremely difficult factual inquiry, which is, one might say, the whole point of the structure. Nevertheless, on the facts which you need not be troubled with, it was held highly likely that Mr. Scurrigan was indeed the holder of the oral mandate and therefore able to control the Foundation's interests in Pikewell. And it was held on that basis that a receiver in aid of equitable execution under Section 37 of the Senior Courts Act could be appointed over those membership interests in Pikewell.
Pikewell was a UK LLP, you say?
Correct, my lady. And the juridical basis for doing that was that Mr. Scurrigan had a right to call for those assets or has de facto control over those assets.
Could you repeat that last sentence?
Yes. The juridical basis for the granting of the receiver was that Mr. Scurrigan had a right to call for the assets or had a de facto control over those assets.
Thank you.
And that will have been via his status as holder of the mandate. And, my lady, I don't think we need to call it up, but for your reference, that is in paragraphs 46 to 48 of the judgment, page 4397 of the bundle. And there is also a discussion, if your ladyship wishes to go down into a little bit more detail, as to what kind of assets one can impose a receiver over at paragraphs 38 to 45, which one finds starting at page 4395. And one would see there that the talk is to the, my friend called it the Tazaruf, I call it the TSM and Merrill Lynch case, the one in which the Privy Council imposed an equitable receiver in order to revoke a discretionary trust in the Cayman Islands in order to then obtain the assets to enforce a Turkish judgment. And that is discussed there. But that's what VTB and Scurrigan is about. Again, the properties that are the end game in that case, which I believe were beauty parlour in Bologna and other properties in Italy, are available to the judgment creditors of Mr. Scurrigan. And indeed, it was said by Mr. Justice Bright that these were the only assets that anyone had been able to identify that they could get their hands on for Mr. Scurrigan. He'd not answered disclosure orders, he was in contempt of this court, of the English court, etc. But
the critical point here is that Mr. Scurrigan had a legal right to call for the assets to be transferred to him or to his order. Isn't that right? That's, I mean, it's that he could procure those assets to be his own and would therefore be available for execution. And so an order could be made against an in personam order made against him to require him to do that, and then you appoint a receiver or whatever to take that step.
Yes, and
I mean, the simple fact of having control over assets wouldn't be enough. You have to have control such that they become your assets.
yes, although the discussion was put on those two bases.
Well, I know, but I mean, the board of BP has control of BP's assets, but it doesn't mean you can execute against BP's assets a judgment against a director.
No, I agree with that, my lord. I agree with that. We're not going that far, but BP's safe, I think, from my client's enforcement process. So, my lady, one can see there that how far back. If you start with the story that well, they can move those assets over there because they don't belong to the debtor, So 423 isn't engaged, there's no prejudice, etc. to the debtor. And we say, well, actually, no. In the modern world, we've recognised with our enforcement processes, which are becoming increasingly sophisticated, because they need to be, they're meeting up with sophisticated processes. And I always say that there's a sort of an evolution that goes on between what happens with those who devise these structures and our process of attaching and enforcing and freezing them. And one has a sort of almost annual debate where those who draft these foundations and asset holding structures work out what the courts have done in places like here to impact the success of the structures they've set up, tweak them, and then people like me have to come along, work out what the tweak is, and then try and persuade a commercial court judge or chancery judge that they should reflect that tweak in a freezing order to cover it and be effective. And the argument you use is that it's accepted that the freezing order or receivers, etc., are there to aid the ultimate enforcement process. And if their step is being taken to defeat that process, then there's good reason to extend the freezing order accordingly. And that's where there's that sort of relationship between enforcement procedures and also the freezing order itself. So, my lady, I hope that's...
Yes, that's very helpful, thank you.
Addressed the question. Turning then, if I may, in terms of today, what I'd like to do with your lordship's and ladyship's permission is to really focus on where we got to at the end of yesterday, which is the only issue this court is concerned about, namely whether or not the appellants are correct to say that one needs a transfer of a beneficially owned asset in order to trigger Section 423. And I really want to just look at that. I mean, I appreciate he's expanded it with liability, etc., but it's expressed in those terms, and I just want to look at what is the basis that can be relied upon or support such an allegation. And in doing that, what I'd like to do is to briefly look at how their case has evolved from the beginning, not to make sort of forensic points so much as to just make this overall remark that the movable feast as it is, and we're not sure whether the movement has ended, is plainly not the best starting point for imposing any hard, bright lines on the ambit of Section 423.
Well, it may have moved, but it has to stop at this court.
My Lord, yes, but of course, if this court was hearing my friend's arguments a few months ago in the Court of Appeal, they would have not had the liability issue, and if no one had addressed their minds to that, hard, bright lines might have been imposed at that point, which then need to be re-examined. It's the danger of the hypotheticals, saying that it must have this and it can't work without it.
Yes.
And then one says, but what about this example? And we'll go on to look very briefly about bank transfers, but what about this example? Then you have to find a reason to bring that example in, because it's obvious nonsense that it's outside. Well, we agree it's nonsense it would be outside, but do we, the idea of having to continue...
But it works the other way, that there is some way you'd say it wouldn't be nonsense for it to be inside, but then I think you say there are other ways of getting it out of the box if subsection 1 brings it in.
Yes, I mean, one of our main points would be that it's just simply the wrong approach to focus on Section 423(1) in isolation of 423(3). So I'll briefly address the evolving case, but I will keep it brief. Then look at a right pace through the wording and purpose of Section 423, because we do say one of the striking features of this case is the agreement between the parties as to statutory principles or principles of statutory interpretation. But then when one comes to apply them, you have on the one hand a completely orthodox approach adopted by the Court of Appeal, looking at the wording, looking at the purpose, to the extent taking into account legislative history and coming up with its answer. And then we have my friend's written case, which wasn't really expanded on yesterday already, that one starts from trying to find some common rationale and then working out some answer from a common rationale of several different statutory provisions or simply one aspect of it. And
Well,
we say,
this court is not likely to depart from the guidance it's given in the case of O.
my Lord, and my general submission on that point would be that the Court of Appeal adopted the right approach and got to the right conclusion. And if my friend's approach, based on common rationale, leads to a different conclusion, it should be rejected because it was the wrong way of getting there and it is the wrong answer anyway.
Thank you.
My Lord Stevens, I think, asked yesterday, my friend, what do you say the purpose of Section 423 is? And we pray and aid very heavily the actual wording of Section 423(3) as the statutory purpose, but we're content, as the Court of Appeal were, to adopt my friend Lord Richards in the BTI Sakana case. And this, the reference in the Court of Appeal judgment is paragraph 81, page 227, and they quoted two aspects of Lord Richards' observations. The first one is that it's the development of a remedy designed to deal with transactions deliberately designed by debtors to prejudice the interests of actual or potential creditors. And secondly, it is a wide-ranging provision designed to protect actual or potential creditors, where a debtor takes steps falling within the section for the purpose of putting assets beyond their reach or otherwise prejudicing their interests. And we say that that's plainly heavily influenced by Section 423(3, and rightly so, and that's what underlies the objectives behind Section 423 as a whole. And then finally, since my friend, we say in our respectful submission, cannot find sustenance in the actual wording or purpose, he's forced to look outside in his common rationale, which I'll deal with briefly as to why I say that's wrong, and then turn briefly to Clarkson and Clarkson, although many of the points have already been made on that case in any event. Given the helpful indications of the court yesterday as to what we were not concerned with today, I've been able to cut down those points, and so it may be, I don't know whether I'm going to be too optimistic, that we may finish slightly earlier than our intended timetable. So turning then, first if I may, to the Appellants evolving case, we obviously accept that as the arguments progress up the appeal ladder, they become finessed, revised and refined, and there's nothing inherently wrong with that. But where the argument is premised, as this one is, upon an allegation of a carefully constructed statutory scheme which is said to mandate a very particular interpretation or restriction on a transaction at an undervalue, we say that it is relevant to see how that scheme argument has been able to give rise to differing answers along the way. And there are 5 points, if I may, to just briefly highlight. The first is that the case was tied to the bankrupt's estate under Section 283 initially. For that, if I can ask you to go to page 424, which is the paragraph 9, and it is the skeleton argument of my friend at the Court of Appeal level. And actually 423 would be a starting point. And one can see in 9.1 that he says Clarkson and Clarkson is binding authority in this court for the proposition that a transaction in this context must involve the giving away of property which would otherwise have formed part of the debtor's bankruptcy estate as defined in Section 283 of the Insolvency Act. And then it said corporate assets belonging beneficially to a company do not belong beneficially to its shareholder, and so would not fall within the scope of its shareholder's bankruptcy estate for the purposes of Section 283, and nor are any powers that the shareholder may have capable of falling in there. And then at 433, paragraphs 36 and 37, the appellants address the somewhat surprising proposition that Section 283 should have anything to do with Section 423. So it's not that they just simply omitted it in their understanding of the scheme. They address it head-on as to why 423 should be limited by the terms and ambit of Section 283, saying that it must be answered the same within and without insolvency. But the difficulty with that argument is that Section 283 doesn't apply at all to Section 423. I'm going to spare the court the somewhat convoluted way of establishing that by reference to various groups of parts of the Insolvency Act, but the Court of Appeal properly notes that at paragraph 66, page 224. So it's simply not possible to have an argument that 283 applies to 423 in or outside of the insolvency process, although they sought to put forward a case that it did. Now one struggles to find, in my friend's written case before you, any references to a case on Section 283. It's been jettisoned. And it's been jettisoned because it simply cannot be correct. The scheme simply isn't that 423 is tied to 283. The scheme, if there is one, is that 423 is expressly not tied to 283. But that raises a question. If one jettisons 283 from the allegation against 423, where does that leave Section 339, to which Section 283 does apply? And if Section 283 applies to 339, without going into the details, 283 excludes certain items of beneficially owned assets from the scope of the bankrupt's estate, which would apply to 339, but wouldn't apply to 423. And to the extent relevant, neither would it apply to 238. So certain personal tools for work, etc., would be excluded, and other matters, personal claims, etc. It's not for me to answer those questions, but it is to raise those as issues that arise when one is suggesting that there's some carefully calibrated scheme involving all of these provisions acting in unison, and they must act in unison, according to my friend. Secondly, as you will have seen from the extract of his written argument before the Court of Appeal, the interpretation of the ratio of Clarkson was tied to 283. That point can be made clear in paragraph 55 of the particular written case, page 440, this before the Court of Appeal. It says,
sorry, this is his skeleton.
Skeleton, sorry, before the Court of
so
Appeal.
That's page
440. Clarkson is therefore binding authority in this court for the proposition that a transaction must involve the giving away of property that would otherwise have formed part of the debtor's bankruptcy estate under Section 283. Now, one rightly jettisons 283 in respect to 423, but in principle that shouldn't alter how one then interprets Clarkson, which was dealing with 339 and 283. Thirdly, it is right that before the Court of Appeal orally, the Court of Appeal was addressed in a much broader argument based upon the transfer of a beneficially owned asset. And the Court of Appeal noted that, paragraph 58, page 223 of the judgment. So the first point I would make there, my lords, my lady, is that the Court of Appeal was addressing expressly the wider argument based upon the transfer of a beneficially owned asset being required. but we would make the point that the case was still one limited to that transfer of an actual asset beneficially owned by the debtor. No mention of any further iteration or revision at that stage. And the fourth point is that we have a revised version put in the written case here relating to liability. And that's had to come in because established cases such as guarantees do not sit within the core of the need for a transfer of a beneficially owned asset. So it represents yet another shift to accommodate established cases. One then might ask what is left of the primary argument of the need for a transfer of a beneficially owned asset if in fact mere liability alone suffices. And what then are we talking about when we talk about liability? In the case of guarantees, we're talking about contingent liability, a liability which may or may not, and hopefully never will, be crystallised. And if it is crystallised, need not necessarily be satisfied by reference to enforcement on the assets of the debtor, because a third party could satisfy that debt. But that is said to be within the revised case. Does it also include a case of damages? So now are we saying that any form of liability that might impact, but need not impact the debtor's assets will fall within 423. I don't know what the answer my friend would give to that, but if one stands back and asks, what are we doing in characterising the transaction? We started from a proposition it had to be a transaction involving an asset defined within 283 to it had to be the transfer of an asset owned by the debtor to liability, which when properly understood is potential liability with potential enforcement on an asset. Now when you get to this category down here, that would be a very odd way of characterising a transaction to fall within 423. I mean, if damages are included, you're characterising not the performance of the transaction, but the breach of the transaction as the means by which one then gets to the assets.
I'm sorry, I'm just getting a bit lost.
I apologise.
With the reference to damages, yes. How does this arise?
Well,
I mean, are you positing a collusive action against the debtor in which judgment is entered for damages?
Well, what I'm looking at is what is meant by the word liability.
This is in their proposition 3B.
Yes.
That it must be shown to engage the TUV test is that D has A, caused something valuable to be transferred, or incurred a liability, which if enforced against the debtor could
lead to
delete. Yeah.
I mean, if it was a genuine claim for damages and judgment for damages, it clearly wouldn't be within 423, would it?
No, it would have to
be a collusive.
It would have to be a collusive one. But then,
and then the argument is, well, that will be enforced and thereby
yes.
deplete the debtor's assets.
Yes, I accept that, my lord. Yeah. I accept that. Yeah. And then a further and final shift, at least as far as I'm aware, was the saving of the bank transfer by reference to tracing. Tracing. Now, it's certainly no part of our case that a bank transfer should be out with 423. But my friend has to do some shifting of the feet to get it within his case of 423, because it isn't.
Just unpack the bank transfer example, if you could.
Yes.
Yes.
A bank transfer, it's settled law that a bank transfer does not, in fact, involve a transfer of property from one bank to another. So when we're told that the case involves or requires under 423 the transfer of a property from one bank to transfer of property from one person to another, we raised the issue, does that include a bank transfer, where the courts have been clear no such transfer of property takes place. One has an extinguishing of a debt to the bank and the creation of a new one, which isn't the transfer. Now, I'm not trying to take technical points here. Plainly, to the man on the street and with good sense, the flow between a bank of such funds would be seen to be the transfer of the funds from A to B. But my friend's having to rely upon the concept of tracing to get him there in circumstances where his primary case, on our understanding of how bank accounts operate, wouldn't apply. Now, we may be right about using tracing to get there.
That seems a very elaborate way of characterising a disposal by the debtor of the credit balance in his bank account. I mean, do you understand the appellant's argument to be that there has to be not simply Section 43 is not simply directed at assets beneficially owned by the debtor, but is further restricted to a transfer of those assets?
Yes.
And what about what about this example? So, the debtor is owed £100 by A. The debtor unilaterally releases that debt. Surely that would be within 423, even on the appellant's case.
Firstly, you get no argument from me that it's within 423.
There's no difference in that between that and handing £100 over to B, another person.
But it would be very odd. I agree, my lord, that the impact of that relationship plainly. It doesn't matter.
I mean, it can't be restricted to transfers of assets beneficially owned. It must include disposals of assets beneficially owned.
Well,
I mean, I think
it's my friend's case, and therefore...
Is that right? That is his case.
That's our understanding. He uses the language of transfer of beneficially owned assets.
I see.
I believe...
Yes, I think in paragraph 6.2 on page 100,
right,
where the debtor causes the transfer of property which beneficially belongs to someone other than the debtor.
Yes.
I mean, if it's interpreted in that way, then it's self-evidently absurd.
Well, that was certainly where we were coming from. So we say that whatever the arguments, and the last point I would just make on the tracing, because I don't want to turn this into some discussion of tracing, but if we're going to go to Foskett and McCowan on tracing, let's start with the basic proposition: tracing is not claiming. So my friend still needs to make good his case once traced that 423 applies. So you don't use tracing to explain the application of 423. He still needs to establish that his version of the criteria of 423 applies post the exercise of tracing. That's
tracing to an asset, but you still have to show the asset is within...
Yes, that during the process of tracing, you haven't lost the proprietary interest, and on his account would be that the tracing establishes that there's a transfer of that beneficial ownership of the asset from A to B and maybe even onwards. But you can't just use tracing rules and then say your claim is satisfied. That view was certainly, and my friend's relying on Foskett and McGowan, that view is certainly not the orthodox understanding of tracing, which is more identification of the flow of value in substitutions and linked transactions, I think is the way Lord Reid had put it in a recent case. All of which may or may not involve formally the transfer of beneficially owned assets. So we just simply, on the involving case, we simply say we're a long way away from where we started, and that one urges caution on the court to adopt the hard and fast rules that my friend is inviting the court to do, based upon a case that is obviously constantly coming up against difficulties and needs to find answers to those difficulties from time to time. So turning, if I can, to the wording, and we make the very obvious point, so we won't labour it, that the general principles on statutory interpretation are set out and well known in our written case in paragraphs 14 to 20, page 158 of the bundle. One looks to the statutory wording of 423 to discern how those words as used would be reasonably understood. One also identifies the target of mischief, as it sometimes says, or the purpose of section 423. And very often, not surprisingly, one gets that from the wording within a section. And here we have a particularly clear indication of what the purpose is, which is section 423, subsection 3. And then in the well-known case in test claimants that we cite in paragraph 18, page 158, if not precluded by the statutory wording, one ought to favour the approach which facilitates that purpose rather than defeats it. We're not in any way suggesting that purpose trumps everything else, that one ignores all the other criteria in section 423, but merely that that's the relationship between the two. And we say that the Court of Appeal did precisely that, and its approach and conclusion cannot be challenged. And that's paragraphs 59 to 67 of their judgment, page 223, and that we address the issue in the same way at paragraphs 35 to 55 of our written case, starting at page 162. Now, of course, Parliament could have chosen to limit section 423 in the way that my friend suggests. But if it intended to do so, insofar as we can properly speak of Parliament's intention, one would expect that such a restriction, particularly one that's considered to have such a critical role in the operation of 423, would be heavily trailed in papers and discussions and commentary leading up to and in the immediate aftermath of section 423 being enacted. And that isn't the case. One would expect it to be expressly spelt out in the wording of section 423, and again that isn't the case. It is odd, to say the least, that such a critical element would be left entirely unsaid anywhere in the wording of 423. And to the extent it's relevant, you don't get any assistance from looking at 238 or 339, which similarly don't have any words that contain such a restriction. One wouldn't expect for such a critical element to be left to be worked out, particularly by the process that's set out in my friend's written case. It makes no sense as an approach to statutory drafting if that was the intention. And if it makes no sense to approach the drafting of section 423 in that way, it makes no sense to interpret 423 in that way. When one turns then to the statutory wording itself, which we address in our written case at 35 to 65, starting on 162, we make the obvious point that, and it's not controversial, that it is widely drafted, and that, as Lady Justice Arden put it in Hill and Spread Trustees, there is an inbuilt elasticity to it. And we say that the Court of Appeal shouldn't be seen to be, or characterised as engaged in some exercise, as it's been put against me, of radical extension. It's much better, more accurate to say that my friend's case involves seeking to impose quite a radical restriction on the operation of 423. But the inbuilt elasticity and flexibility is precisely what one would expect of a provision such as 423, and what it is designed to combat the mischief that it's aimed at. And as we've seen in the cases we looked at briefly this morning, it can be quite a convoluted process to get hold of those assets but those assets are available if that process is followed through and available. And if they're available, they can be dealt with in a manner which prejudices the interests of creditors. Second point, when one looks at wording such as transactions entered into at an undervalue, 2 points. One is obviously not going to find any wording there to support the proposition of transfer of a beneficially owned asset, or indeed the involvement of a beneficially owned asset. But what you do see is the reference to value. And we do think that value is important because it's not what the assets are of a debtor that is critical to the creditor's interests, it's the value of those assets. And if one takes steps to impact the value of those assets, that is as much of a prejudice to the creditor as would be reaching in and taking out any particular assets and throwing them away. The creditor no longer has as much as a valuable an asset base against which to enforce in both scenarios. But there's no language there to support my friend's case. Interestingly, the drafters in the Insolvency Act, when they were focusing on property being moved and wanting to emphasise that, they have used different language. And Section 127 is an example which is available at page 544 of the bundle. This is avoidance of property dispositions, etc., after the commencement of a winding up.
Could I have the page number again?
544, my Lord.
Thank you.
Section 127. And one can see there any disposition of the company's property. And the language of disposition is used in respect of the property and the identification of ownership of the property. Similarly, in Section 284, at page 591, 591. Oh, that might be. Apologies. That's a misreference. 592. Yeah. Whilst that doesn't identify ownership of property, it does use the language of disposition of property. So, just standing back, and I'm not saying these points are decisive, but when you're faced with a case based upon a carefully calibrated scheme, allegedly, in the Insolvency Act as a whole, it's odd, to say the least, that one adopts certain language in some provisions dealing with property dispositions and not in Section 423, or indeed the related provisions in 238 and 339.
We have in the bundle at page 562, Section 242, which is in the same group of sections as Section 238, a provision applicable to Scotland only, gratuitous alienations. And I wondered whether you got anything out of that section, in particular subsection 2, so page 562.
Any part of the company's property is transferred away, or any claim or right of the company is discharged or renounced.
Yes, I mean, of course, it's dealing with a different system of law.
It is.
But it is in the same group of sections.
Yes, I mean, we did wonder at one point whether to introduce the Scottish element, but the Scottish question we didn't decide. We decided it wasn't necessary. But I take your Lordship's point that, given the drafters are dealing with this in the same Act, it is further grist to the mill that if they had in mind the limits on the operation of 423 suggested, that they would have been inclined to use similarly carefully worded provisions.
Yes, I would be careful to read too much into the Scottish provisions when interpreting the English provisions. Scottish property law and insolvency law have very different antecedents, and the law of gratuitous alienations go back to a Scottish statute of 1621, which is worded in different terms. So I understand your reticence in seeking to take much from Section 242.
I also understand from Mr. Delahanty that the Scots law has a common law of anti-avoidance provisions which bear on these terms in their provisions, so they may have a meaning. But my point, absent the Scottish provisions, remains the same. And of course, when one looks at the definition in 436 that you did yesterday as to what a transaction involves, one sees a broad and inclusive and non-exhaustive definition, but not one in any way pinned to the question of transfer of beneficially owned assets. And that's really where I'm sort of focusing on. How do I get this restriction out of the provisions? And I take your Lordship's point, even if it's not transfer of, I'm not conceding, I'm not trying to help my friend, but even if the focus has to be on a beneficially owned asset being handled, that's not there. That's not supported in the wording. Now, fourth point, the Court of Appeal was correct in saying to get those words in there, you need to have some additional wording in order to put that restriction. And that is consistent with our view that what's really going on here is an attempt to cut down the operation and scope of 423, not to prevent its expansion. It's to cut it down, and the Court of Appeal was correct because, as they said, there's no reference to property or assets beneficially owned. Now, the court report, which was heavily trailed by my friend before the Court of Appeal, did put in some wording that it suggested might be used. Precisely why it was suggesting that wording, I don't know and can't say, but if one looks at 4643...
Sorry, can you give that?
4643, my lord. And there's a summary in 1283 of what they're proposing for the new provision. And you can see in A, it applies to mere payment of money as well as to any disposition of property over the money. So they've used the language of disposition of property. And for the purpose element, in 4629, yes, at the top of the page, little b, that the necessary intent is an intent on the part of the debtor to defeat, hinder, delay or defraud creditors, or to put assets belonging to the debtor beyond their reach. And that such intent, and then it goes on to say, should be inferred from the consequence. But neither proposition was taken up by Parliament drafters, but one can see the wording that was in play in the report that leads up to the Act and is discussing what to do with the Act, and neither of them are included in the final outcome, even though the language of disposition of property is used elsewhere when that is what is clearly in the mind of Parliament. The fifth is that it was said against me that the Court of Appeal...
Sorry, in A there at the top, 4629, where it says applies to mere payment of money, is that addressing this bank transfer is not a transfer? It may be too early for...
Yeah, it was more that under the previous legislation, 172, there was an argument that it didn't apply to certain types of movement of assets, and payment of money was one of them. Now, the fifth point is that you cannot read from the Court of Appeal's decision a determination by the Court of Appeal that sections 238 and 339 can be read as limited by my friend. Because the point is made against me, well, the Court of Appeal said, we're not prepared to read it into 423. The inference being they would have been prepared to read it into 238 and 339. The Court of Appeal simply wasn't engaged in determining the ambit of 238 and 339. The focus was entirely on, as was appropriate, the ambit of 423. So the context is more, whatever you say 238, 339 is about, 423 doesn't contain that restriction. But we would say, logically, everything that the Court of Appeal says as to why it isn't in 423 in terms of the need for additional words plainly applies to 238 and 339 as well. But my principal point I want to make here is the fifth point, is that the Court of Appeal does not accept and can't be read as accepting that the restriction does apply in the wording in 238 and 339. The sixth point I'd like to make is that, contrary to the appellant's case, we don't accept that one can read across from an understanding of gift that transactions at an undervalue must involve, all transactions at an undervalue, or certainly those in 4231A, must involve a transfer of a beneficially owned asset. We say that the language of otherwise suggests this is other than as a gift. And certainly noted commentators have no difficulty in accepting that the transactions at an undervalue in 423 for no consideration do not need to involve the transfer of an asset at all. And two such commentators, if I could very quickly show you the paragraphs. The first is Rebecca Parry and Mr. Shivji at 5203 of the bundle. 5203. Paragraph 4.15. Where they make the point, as your lordships and ladyship will see from that paragraph, that it doesn't necessarily entail the transfer of an asset. And Professor Good, sorry.
So they assume, as my Lord Richards said, they assume that the forbearance or waiver of a debt would be included.
Yes. But absolutely, my lady. But the point here is that you can't read across from gift into transactions that the transaction itself must involve the same constituent elements of a gift, namely the transfer of an asset. And Professor Good, who probably knows more about this area that I've forgotten, he's forgotten more than I know, is probably a better way of putting it. Not praising him in the right way. At 5058. 5058. He makes the same point halfway down the page under distinction between gifts and other no consideration transactions, paragraph 1324. And he similarly, my lady, refers to the same sort of examples. So we say when one looks at the wording, one simply doesn't get the restrictions out of the wording. That's with respect, a damning start to my friend's case, if the wording do not support such a critical conclusion and restriction. And that's before one turns to section 423, subsection 3. And
neither of these passages you've shown us address the issue we're concerned with.
No, they don't. They don't. What they do address is an attempt to limit transaction to an understanding of a transfer of a beneficially owned asset because of its relationship to gift.
I see.
That's the limit of what I'm taking from it.
I see.
But no, your Lordship point is really probably why we're here, because this issue isn't the subject of any sort of detailed discussion. Otherwise, you would have been inundated with copies of whatever from whoever's side, etc. It's just not there. So I'm afraid we'll all be looking to what this court says about it for that going forward, and no doubt that will generate plenty of material going forward. Turning then to 423 subsection 3, and I put this also under the heading of statutory purpose for the reasons that I've trailed already. We deal with this in our written case, paragraphs 21 to 30, which begins at page 159. And there are obviously two aspects here. One is the putting assets beyond reach, and the other one is otherwise prejudicing the interests of. And, my lady, the examples we've been discussing in the morning can be said to fall within both headings, because obviously it doesn't use the language of putting the debtor's assets or assets belonging to the debtor beyond reach. It just talks about putting assets beyond reach that would otherwise be within reach. And as shown this morning in those examples, those assets ultimately in London and Bologna and other parts of Italy were available through that process, and therefore would be if moved. But on my friend's case, would not be caught. But we say 4233 serves two main purposes. The first and most obvious point, it is part of the statutory wording of the 423 claim. So to hive off 4231 and try and understand what that's all about, independent of and completely divorced from 4233, is not the correct approach. I think
this raises the nub issue that we've got precisely the same formula, not just an expression, but a whole subsection with paragraphs, exactly the same template used in 3 different sections in the same legislation.
yes.
And there must be surely a strong, not necessarily decisive, but strong presumption that Parliament intended each of those provisions to mean the same thing.
Yes, my lord, I would accept that with this proviso. At what level one is talking about meaning the same thing? Because as we set out, and I wasn't intending to go through the process, as we set out in our written case, and as the Court of Appeal adopted, yes, one can understand that when Mr. Justice Millett gave guidance in one case as to what a transaction of an undervalue means, that is helpful and can be helpful across the board with the others. But that understanding what a transaction might be is one thing. Imposing a restriction on the content of that transaction is a much more granular approach to understanding the meaning of the word. So, as the Court of Appeal said, yes, one can operate at a certain level and understand that there's guidance that transactions mean transactions, so perhaps the drinking of one's own wine isn't going to get you anywhere under any of them. But an understanding of what a transaction is would. But then you move deeper. When you start moving into the content of the transactions, the deeper you go into the content of the transaction, that's what we're talking about, the deeper you go into that, the greater the differences that will arise between the statutory provisions, because they're doing different things. And so, if you look at
different I mean, one view of it is that the different thing is actually in section 423 the mental element, the purpose. In the other section, so the reach of the sections is determined by those provisions, but applying to the same set, if you like, of transactions.
But yes, my lord, but then if you look at the purpose, if you look at section 423 and the two provisions in 423.3, that informs what kind of transaction is triggering.
Well, but that does mean, does it, giving different meanings to the same words in the different sections?
Well, it doesn't mean. One can understand what a transaction is at a high level, the general guidance, whether it involves mutual dealings, whether it includes dividends, etc., what have you, without having to say, put a clean, hard line that it must not or it must include X.
But I suppose, I mean, the question for us is a narrower one, isn't it? Is there something in sections 238 or 339 as opposed to 423 which would require the answer that those sections should be limited in the way for which the appellants contend, which, and then the question is whether that limitation has to be read across to section 423 or not. We're not here concerned to produce a definitive guide to what a transaction is. We're here to address the one issue that is raised on this appeal. So really the question is, in that context, is there any reason why there should be a different answer to that question depending on which of these three sections you're looking at?
We say no.
But I think it's an important issue. Yes. For the reason that I gave, yes, of the obviously strong presumption that that Parliament is likely to have intended a single meaning.
Well, in terms of the language, the statutory language, up to your Lordship's obviously paused me at 4233. So
well, because I knew exactly where you were going with
yes. it. But you paused me at the point where everything I'm saying applies to that same language in 238 and 339.
But you can't rely on 4233 to interpret that language in 238.
Well, I'm going to try and make good that point that I can. Okay. But everything I've just said to the point you paused me are arguments that apply on the wording that's reflected across the board, because that's at the transaction at an undervalue level. And we said there's nothing there that compels this court to read into 238 and 339 the restriction that my friend says. We do also, and your Lordship with respect is correct, that there's a danger in thinking this case is driven by 238, 339 when it's a 423 case, and we must focus on 423. But you're right that to look at the question, and at the moment the answer for me is affirmed. There's nothing in the wording that compels that they ought to be interpreted in the way my friend would like them to be interpreted. We do, however, and I appreciate there's some resistance from your Lordship on this, but I'm going to go into the lines then on it. We say you simply cannot salami slice 4231 from 4233. That one needs to take into account all of the statutory wording in order to understand what's going on. And my principal point in respect to 4233 is that if it was intended that the transaction to which 4231 or 423 applies was to be limited, as suggested by my friend, then it is at least difficult to understand why 423 and the statutory purpose was expressly drafted in such broad language which plainly goes beyond such a restriction. Now, I've made the point, if this was what Parliament intended on the language of transaction and undervalue, it could have, should have, and didn't spell it out. And if it's so critical, that's all the more odd that it didn't. But equally, we say here that if that's the interpretation, and they've not spelt it out at the 4231 level, why on earth are they drafting a statutory purpose that plainly goes beyond such a restriction? And we see you cannot ignore that when looking at 423. However uniform, one might think it is sensible to approach the question of transaction and undervalue across 238 and 339.
In subsection 3, the opening words are it's entering into such a transaction, so it is limited to transactions falling within subsection 1, clearly. But when one looks at, takes the examples of somebody drinking all their wine or throwing the valuable painting on the bonfire out of spite, if they may well do so with a purpose which falls within A or B, but it's not caught by 3 because I think you would accept that that's not such a transaction.
Yes, I mean, 3A and B, the purpose, is clearly written in broad language, but it does refer back, and we accept refers back to transaction at undervalue. But if the transaction at an undervalue is not itself curtailed or circumscribed by the proprietary argument that my friend says, then one looks at the purpose and can see that you could enter into a transaction not so prescribed. What does the purpose say? It presents two possibilities. One is putting assets beyond reach, and we've seen what that can mean and how that could incorporate a transfer at the corporate level, or otherwise prejudicing the interests of such a person in relation to the claims making. Now, I'm a little bit loath to talk about hypotheticals because I think it's always dangerous because we've not really focused on facts. But if the bonfire of the painting, there would be an obvious argument as to, well, you may be prejudicing the creditors, but how does that fit in with what 423 is really all about? But if you're not circumscribed by the 4231 definition of transaction undervalue, you're not only not circumscribed by 4233, you're positively encouraged as to where it goes, because our approach to statutory interpretation, as I understand it, is does it fall within the words, if or not precluded? I think my Lord Richards in BTI Sakana used the negative. They're not precluded by the words. Then does it facilitate or defeat the statutory purpose? And we say we fall within the words of TUV, not circumscribed by any proprietary right restriction. Does it facilitate or defeat the purpose? The Court of Appeal was absolutely clear it facilitates the purpose. We are absolutely clear in our respectful submission before you that it is, but it's equally clear that the Court of Appeal rejected the approach adopted by my learned friend in stringent terms, saying that their argument would, quote, easily defeat the purpose of section 423. And that's at paragraph 63 of page 224. Easily defeats the purpose of 423. Now that, with respect to my friend, is a damning indictment. And if one applies standing understanding of the statutory approach, one is left with the undoubted conclusion that the wording is wide enough and the purpose facilitates it rather than excludes it. And the point, just going back to my friend's point, my Lord Justice, Lord Richards, I think the point is well in mind, but 436 definition obviously does start with in the context, and the point I made very badly before was as one gets further down in the granular as to the detail, the greater the context of the application of these particular provisions arises. But I don't want to go back on that point. I just wanted, that's how we see that operating. And obviously the Court of Appeal considered context was important. But the way I've just...
I found it difficult to understand. I mean, did the Court of Appeal rely on the exception words at the beginning of 4361?
Yes, they did rely on context.
But the danger of doing that is that you actually narrow the meaning of transaction. I mean, if you proceed as I do on the basis that it's not a definition as such of transaction, an interpretation is an expansionary definition, if you like, then if you say the context otherwise requires, well, you exclude the expansion and you end up with a narrower meaning of the word transaction. I found it a bit... I couldn't actually quite understand why the Court of Appeal was relying on those opening words.
I suspect I took them down a garden path.
Do you support that now?
Well, I do, in the sense that if it's said against me by my friend that there needs to be the granular, then I say at that level of what is the content of a transaction, I do question that, and I say that 423's content is, as I've put it forward.
Saying the transaction could be read more widely than 436 provides.
Well, if that point doesn't find favour, then the way I've just addressed it to my Lady Rose, namely statutory wording of 4231 does not exclude it, and the statutory purpose positively includes it, then one's home with the traditional approach to statutory interpretation.
So you would say actually all the things that we've pleaded that the appellants did fall within the includes wording in 236 and would be transactions within that definition without needing the wiggle room that the opening words of 236.
Yes, that's exactly the way I put it to your ladyship. That's exactly how I would say. So if your lordship is against me on context, that in any event we're saying that the wording of the statute is wide enough and the purpose positively encourages it to be included.
I mean, really
that's using the two sections separately, if you like.
I mean, there's nothing actually in section 436 that really directly touches on the issue which is before us. But the word arrangement, I mean, given that there has to be two parties, even if one of them is passive, I mean, that's clear, there has to be A and B. The word arrangement is an exceptionally wide word. So it's hard to see why the context might require an even wider word.
No, but your lordship may be right. I think
the word arrangement is usually put in to expand an agreement to cover something that is informal and wouldn't necessarily amount to a binding contract applying our contract laws. It can be something less than...
Yes, absolutely. I mean, to be fair to the Court of Appeal, they wouldn't be the first court to have looked at the purpose of 423 to consider the definition of transaction. I think Lord Justice Jonathan Parker prayed that in aid directly in Feakins as well. And then turning, if I may, so you have my submissions on purpose. And then the final very brief point I wanted to make on the statute itself was the remedy function of the statute, which we deal with at 13.4 of our written case, page 157. And the only point I want to make on this is that the argument, if I can call it this, the common rationale or the structural argument that my friend raises in his written case is one that suggests that, like a game of Django, the cards and everything else come crashing down if you if you don't require the beneficial interest transfer requirement. And the simple point we make is that the 423, like section 238 and 339, is a highly discretionary remedy. There's nothing objectionable about that. It is well accepted that that is a deliberate part, so that one gets through the gateway, a very wide gateway, that then the court can fashion an appropriate remedy, or indeed decide there's no remedy at all on the given facts. I think my Lady Rose said at first instance in BTI that, or certainly endorsed, that there were no hard and fast rules.
Well, we had to have a whole very substantial hearing about the remedies.
Absolutely. And so what we say is that what's being presented to you, although it wasn't really trailed yesterday orally, is that there's potential that if you endorse the Court of Appeal's approach, that the distinction between everywhere all these provisions comes crashing down. And I'll deal with common rationale in a moment, but we say there isn't a hard and fast answer. If the same factual scenario might be viewed from more than one perspective in terms of more than one statute, then you look at it, you apply the criteria of the particular section and decide whether or not it's available. Now, if a preference also amounted to a transaction at an undervalue in any given circumstance, if it did, and therefore 238 or 339 were engaged, one might very well find a presto that the claimant takes the easiest route to getting some form of relief, the one that doesn't require them to need to establish a statutory desire in the particular transaction. Nothing surprising about that. Claimants and litigators do it all the time, finding the easiest route when, certainly in cases dealing with fraud, you can be presented with a myriad of opportunities of what kind of claims could be made from the same set of facts, and one just decides what's appropriate to your particular client and the evidence that you have. This is, and the statutory remedy, being so discretionary, fits in with 423, perhaps more so than ordinary common law equitable remedies, because it expressly tells the judge that they have a wide discretion on how to fashion a remedy, or decide there's no remedy at all. So then, if I may turn to common rationale argument and just deal with this briefly, if I may.
This is the aggregating 423, 238 and 339.
Exactly, my lady. We say that we're only here dealing with the common rationale argument because my friend recognises that the wording and the purpose of 423 itself doesn't get him home. So he seeks to find an answer elsewhere. And we reject it as an appropriate approach to statutory interpretation. And insofar as an approach, it gives rise to an answer which is inconsistent with Court of Appeal decision that has applied the correct approach to statutory wording and purpose. We say it cannot stand in the light of it. But as I understand my friend's case, it is that the transaction at undervalue is intended to keep preferences separate and distinct from what he calls the avoidance provisions, namely 238, 339 and section 423. And that it is absolutely critical that there can be no overlap between the provisions. And then it is said, as I understand it, that the beneficial interest ruling of the Court of Appeal, i.e. they don't require beneficial ownership asset transfer, blurs the distinction so that one might have a situation where a corporate transfer is operating as a preference but would be a transaction at undervalue from the debtor's perspective. And then it said that therefore the transaction undervalue must contain the restriction of a beneficially owned asset being transferred. And we say two preliminary points first. With respect to that, we don't consider this to be a meaningful exercise, because one's not engaged in the statutory interpretation of section 423 as a whole, simply one aspect of it, and then one is seeking to find a common rationale between that aspect and similarly aspects of but not whole sections of Section 238 and 339. Sections which operate within insolvency, because of insolvency, whilst 423 operates out with insolvency and is not triggered by insolvency. Secondly, it's left unexplained how the common rationale comes up against and deals with the statutory purpose. Because presumably he's saying, well, it is said that the rationale dictates a certain understanding of transaction at undervalue, and that understanding on his case must be entirely independent of statutory purpose, whereas we say that the statutory purpose, for the reasons that we've indicated, says that the conduct is facilitating that purpose rather than defeating it, that it ought to fall within a transaction at an undervalue. Now, turning to the rationale itself, various ones were examined, and I'm not going to spend time going through each, although it's plain when one looks at them that some will have a greater relevance to some of the provisions than to others. So the reference to assets in family hands and associates and close parties, etc., we say plainly is a rationale that has a greater resonance with 238 and 339 than it ever does with 423, because it doesn't matter in 423 who you give the assets to, but the purpose that underlies the giving of those assets or the prejudicing of the creditor's interests. Now, it is said, as I say, that the rationale that they land on is one that the transaction at undervalue is a mechanism for keeping preferences separate from the avoidance provisions, and there to be no overlap. We generally deal with this.
So they say because preferences must be limited to the transfer of beneficially owned assets by the company or by the...
No, it said that the policy is the preferences should only operate within the insolvency context, and therefore the transaction at an undervalue is a mechanism, that's their word, not mine, to separate preferences from 238, 339 and 423 and ensure it only applies inside of the insolvency context. That's how the case is put. It's put on two levels. One is that there must be no overlap, and the other one is that the preference, the policy driving it all, the preference must not operate outside of insolvency. And our first answer is, well, if you don't want preferences to operate outside of insolvency, put it in the criteria of preferences, which is exactly what's happened. One has drafted preferences which make it quite clear what the twilight period is for their operation, exactly as one would expect. So the great policy driving this common rationale argument of a mechanism is simply catered for in the usual way by drafting appropriately the criteria for a preference.
Yes. Yes. So if a transaction were both a preference and a transaction as an undervalue, for example, if you paid a preferred creditor more than that creditor was due, then you could only go at it for a preference if it was within the time limits of the insolvency set out in the relevant provisions. But you could go with at the transaction as a transaction as an undervalue, regardless of the insolvency.
Yes, my lord. And I mean, your example highlights the possibility of overlap, which is at the heart of this, because that same transaction, what are we to do? Treat it only as a preference up to the value of the debt paid, and then separately as a transaction at undervalue afterwards. No, the way it would be done is it's a preference, and then you would say, and the alternative for transaction undervalue would be the whole transaction. So there's an overlap, but it's not beyond the wit of the court to say, well, let's have a look at what does the preference require? Is that satisfied? And to understand what the preference requires, you look to the criteria. And then we ask the question, is 238 satisfied? And we looked at 238 criteria. And that's when one looks at the evidence of the statutory schemes that's being constructed, and I use that language deliberately by my friend for this argument, and I hope, with fairness to him, it's a clever argument. When you look at that argument, the evidence that he relies upon points back to the language of the criteria for each of the statutory provisions, which you would expect to indicate a difference between the two, because in the main a preference is doing something different than a transaction at undervalue under section 238. So, for example, if you look as regards his argument between 238, 339 and preferences, he says the statutory scheme strongly indicates this common rationale. That's his language, their language, strongly indicates. And that's paragraph 123, page 123 of his case. I do apologise, I'm just going to log back in. That's what he says at paragraph 123, page 123 as well. And we say that simply reflects that each statutory provision is doing something different. So you're bound to have slightly different criteria. It's not in and of itself any indication of some grand scheme upon which one builds some...
The preference isn't necessarily at an undervalue or even usually at an undervalue.
Exactly what I'm laid up, but can be. My Lord Hodges' example shows a potential for overlap. But you're right, that typically preference is neutrally valued.
You release the debt, you pay the debt that somebody owes.
Yes, you're paying a debt to someone in preference to someone else. The whole idea of outlawing preferences or giving a restitutionary remedy for preferences is you're on the brink of insolvency, and the pari passu principle should apply. So, as Lady Rose says, normally there won't be any undervalue at all, but it is at least conceivable that if the preferred creditor is someone to whom the debtor is wishing to transfer more assets, you could pay a sum in excess of what the true debt was.
Yes, and of course preference, it's often forgotten, also includes the preferring a surety guarantor, and one could do that by way of a transaction and undervalue and thereby put the surety in a better position.
Yes.
But your ladyship is absolutely...
Well, we've taken to a case yesterday that says if a distressed company pays off the full value of a debt that's owed, that's not considered an overpayment just because the creditor, if they tried to factor that debt, wouldn't have been able to get the full value for it because of the risk of default.
Yes, I think that's a section from my friend's skeleton pointing out that feature, that
that's right.
Even if in the real world it's considered to be worth more than its pound pence. But
the other aspect is that even if there is an overlap between the two, and the discretion under section 423 could be used to accommodate it, though I've found it hard to see how it could be, but that discretion is available for unusual cases.
Yes, and I'll be coming on in a moment to discuss the different mental elements.
Yes.
Which would apply in those circumstances. But the evil of preference...
It would be reflected, I think, in the remedies, wouldn't it? That, take my Lord Hodges' example, if it was if the claim by a liquidator were made too late, or sorry, that's the wrong way of putting it. Supposing an asset worth 1,000 is transferred to someone who is a creditor for 200, then if one was treating it just as a transaction at an undervalue, then in some way or other, what would be recovered is the 800. I mean, it couldn't be right to require the transferee to retransfer the asset without, in some way, getting credit for the 200 that they've paid. But you could then, if it was also a preference, recover the 200. So they may be overlapping claims, but in terms of the remedies, they're likely to be separated out.
Yes.
And there's nothing with respect surprising about that working out at the remedy stage. And in our written case, just for your Lordship and Ladyship's note, we've set out at paragraph 128, page 193, a surprising degree of overlap in the drafting of sections 238 and 239 with the preferences both within corporate and in individual bankruptcy. And the point we make is just simply this in that context. If it was an essential criteria to keep them separate and not the subject of any overlap, it is just a little odd that they're treated in the same provisions. Even if they're saying different things about timing, there isn't a clear distinction being, as clear a distinction that one would expect in the drafting process if there was some grand policy to keep them separate. If one looks, if I can perhaps just draw, I hope this isn't a bad point, but if one looks at page 599, and this is one of the examples that we rely upon in terms of overlapping in drafting, it just seems to me, in my way of looking at this, that B and C, by saying which is not a transaction at an undervalue. Sorry, page 599.
599.
Yes, section 341, relevant time, under 339 and 340. This is one of those sections in which there is the drafting both time provisions for both in the same provision, which, as I say, I make the point it's a bit odd if there was a grand scheme. But one sees that A deals with a transaction at undervalue, and then B is phrased in a way which rather suggests that a preference might be a transaction at an undervalue, even though it does say in the case of a preference which is not a transaction at an undervalue. And similarly...
Well, it's a recognition of the possibility of a combined transaction,
Exactly.
which is both.
Yes. That's certainly the way I read it, even though its actual terms are, if you were to quote out of context, a preference which is not a transaction to value, that might suggest that they're just emphasising it isn't, but I'm saying that it's dealing with a preference which they're making clear that when they're talking about a preference in this context, it is one that also doesn't amount to an undervalue. So, as regards 238 and 339 and its relationship with preference, we say that the grand scheme that my friend's case is built upon isn't established. There isn't any strong indicator, there isn't any indicator at all that there was an attempt to use the transaction at an undervalue as a means of distinguishing preference from sections 238 and 339, or indeed to prevent any overlap between the two in terms of transaction.
They're simply different mischiefs.
Absolutely.
Yes. One is relating to the disruption of the pari passu principle on the eve of insolvency. The other is relating to the avoidance of a person's debts.
My Lord, yes. And that really is the point when I come to look at 423 and its relationship with preference, as relied upon by my friend for the common rationale argument. And he deals with this at paragraph 130 of his written case, page 124 for your note. And it's absolutely crucial to his argument that you can't distinguish Section 423 from a preference by way of the mental element. Because if you can, his case that you need the transaction at an undervalue in the form he says falls away.
So again, if you can just unpack that a little bit more.
It's central to his argument about common rationale applying to 423 and its application and its non-overlap with preference. It's critical that you can't use the mental element of these two provisions to distinguish a 423 claim from a preference. Why is that critical to his case? Because if they blur together, then he establishes, he says, the need for the transaction at undervalue to do the job of keeping them separate. That's the way the argument is put.
Well, you need the requirement
for beneficial interest transfer in the transaction at an undervalue in order to keep them separate. It's doing all the work when the mental element isn't doing the work. Now, our first point in response to that is it would be surprising, without even looking at the mental elements, that they'd be drafted in a manner that they could so readily overlap. For two reasons. One, because they're aimed at different mischiefs. And therefore the mental element obviously would be directed towards the relevant mischief. And the second one, really taking up my friend's case on a general scheme, if there was this desire, overall policy, that's driving the separate nature of the two and prevent overlap, it would be odd that it's not reflected in, that they would draft, better way of putting it, that they would draft a mental element that could so readily be achieved for both, and therefore potentially blur the distinction between the two.
So what's the mental element again in relation to 238?
No, this is a point only on 423.
Yeah.
This is a point. I mean, there will be, I mean, people say there's no mental element, and it's right, there's no mental element, but obviously one still needs to enter into a relevant transaction that's covered by 238 and 339. But my point here is one specifically targeting 423 and the argument that it is kept separate from preference. And the crucial stage in the argument from my friend is that the mental elements of these two provisions, the preference and the 423, can't do the job. Therefore, his argument on the transaction at an undervalue must do it. And I'm challenging that proposition that the mental elements can't do the job of keeping them separate. Because we say it does. That the mental element of 423 is, as we've been discussed already, one that is tied to the purpose set out in section 423. And if the transaction isn't entered into with that purpose in mind, it isn't a 423 transaction. Whereas a preference is a transaction entered into or is made or is suffered where they're seeking to prefer a desire, statutory desire to prefer a creditor. That's, now, it's said, well, preferring a creditor may have a negative impact on another creditor. Well, that's factually, I mean, I can't disagree with. It may very well do. And possibly unlikely that it does.
Well, it will only do so if you're heading towards insolvency, because otherwise the payment off of one creditor doesn't affect the net assets of the debtor.
And that's why one doesn't need to worry about keeping preferences away from solvency, because by their very nature, the evil to which it's addressed only arises as one approaches insolvency.
Yeah.
But the important point is to say this, that even if factually one can construe the preference of one creditor amounting to the consequence of preferring one creditor, I should say, amounts to prejudicing other creditors, that's not a blurring of the two mental elements, because consequence doesn't satisfy its purpose under 423 subparagraph 3. It needs to be your purpose of entering into the transaction is to prejudice the creditor, not that the consequence is. Now, obviously, I accept that if a conduct is undertaken which has as its consequence and is foreseeable to have as its consequence the prejudice of a creditor, there may be the makings of an argument that the purpose that you entered into that transaction was in order to prejudice the creditor. But it doesn't follow from the satisfaction of the mental element of desiring to prefer one creditor over another, that the other creditor's prejudice is your purpose for the purposes of section 423, subsection 3. And this issue was briefly dealt with by Mr. Justice, Lord Justice Leggett, I believe he was, in the Abel-Husseiny case. It's in the supplemental bundle at page 125. So the point being made, and I'll take you to in a moment, is the consequence is not necessarily the satisfaction of 423B purpose. About 4 or 5 lines down in paragraph 15, he says there's...
Just page number again?
It's 125 of the supplemental bundle.
Thank you very much indeed. Thank you.
Paragraph, sorry?
Paragraph 15, my lord, and it's about 4 or 5 lines down, beginning...
So who's this from?
This is
Lord Leggett in Abel-Husseiny.
Right.
Yes, he's really just saying there has to be an actual purpose.
Yes. And it's not, I'm not here saying factually, in any given case, you won't get an overlap. But what I'm saying is that the actual mental elements are different. They point in different directions. And whether there is an overlap would need to be established on the facts. I don't have a problem if there is, on the facts, an overlap. But the mental elements themselves keep the two claims separate. So by keeping the two claims separate, if I was addressing this court on one transaction that may amount to preference, and I'm also arguing about 423, and no doubt I would be chastised by a court rightly that if I failed to address my arguments within the criteria of each in order to satisfy each. And it won't be enough to simply say, well, preferring one creditor means that you're plainly intending to and have the purpose of prejudicing the other creditors. This is all uncontroversial. I'm only really addressing it because a construct has been put against me that...
Well, it's a big part of the case you're coming to address.
Yes.
Yes.
Yes. And but we see it as not a question of collapsing one provision into another, the language that the appellants use. This is just the stuff of litigation. You look at a complex set of facts and you work out which claims might arise from those facts. And then in respect of each, you plead out the relevant criteria for that particular claim based on the facts that you have. And it may be that you use some of the facts for the preference in support of the claim for 423, but at the end of the day, if I don't have my pleading about 4233 in my case, and I don't make good my case on that, there's no point by pointing to the mental element of preference and saying, Judge, please give me a 423 claim. Because they'll say, well, we didn't examine that point, you didn't raise it, you didn't put the case. Consequence alone isn't enough.
Yes.
So that's really all I'm saying on that.
Yes, I mean, that seems fairly straightforward, because if an individual is giving a preference, he has to have the intention set out in section 344, namely to give the preference. Put the person in a better position than he would be if there was bankruptcy, and quite understandably that's tied to a tight period before bankruptcy occurs. And I think all you're saying is you have to meet that criterion to claim a preference. And similarly, in relation to 423, you have to meet the 4233 criterion.
Absolutely, nothing more than that. But once one accepts that, then one sees that the mental elements are different, and that there isn't then the driving demand for TUV to achieve the purpose my friend says it must.
Probably just me, but at the moment I'm finding some difficulty in seeing how giving a preference, if that's all that's happening, comes within 4231 at all.
It might not.
Well, I at the moment don't see that it can at all.
No.
Because it just doesn't fit.
No.
Because what you're doing is paying a genuine creditor. Well, that paying a genuine creditor doesn't fit within any of the paragraphs, does it, of 4231?
Not simply paying a creditor, but if one overpays a creditor.
Oh, well, that's a different point.
Yes.
But I think the point being it's nothing to do with overpaying a creditor that the appellant's argument goes to, as I understand it. They're saying that it's to distinguish between transactions defrauding creditors and preferences, that there's this common rationale comes in. But my point is I'm just finding it extremely difficult to see how the two sections overlap at all.
But if they don't...
You don't need to look at the mental element, do you? You just say paying a creditor does not come within 4231. How, I just don't see how it can.
No, I mean, I think I was addressing really sort of the kind of example that my Lord Hodge was referring to, where it's a preference up to...
Oh, yes, but well, up to, it isn't within 4231.
Yes. I don't think I was saying anything.
No, I don't think you were.
No, exactly.
But I mean, this seems a very... Anyway.
Yes, but I was addressing the point that's raised, I think it's in paragraph 130 that I gave the note to my friend, that it was the mental element can't do the job that section 172 used to do, which was to distinguish a preference from a claim under 172 of the LPA.
It doesn't need to.
But if it can, the argument that my friend raises isn't right. It isn't right to say...
You don't accept, I think, that it needs to, because you say there can be an overlap, although whether juridically there is an overlap, if, say, you owe somebody £1,000 and because you don't have the cash, you give them a painting or something, which is actually worth more, then you may just distinguish between it being a preference up to the value of debt and then a transfer at an undervalue for the remainder.
Yes, my lady. So the argument put against me that all of that has to be done and can only be done by TUV.
But I mean, it's put in terms in 130 of the TUV test alone must perform, but actually, whether it must do or not, in fact it does.
Which is back to the reality that all we're dealing with here is that these not surprisingly, different statutory provisions have different criteria, and the mischief that preferences is aimed at is different.
Well, it's not exactly, but my point is that 4231 is drafted in terms which exclude preferences. I mean, you cannot, well, I may be wrong about this, but into which slot in 4231 would one put a preference, simply a preference, not a preference plus a transaction at undervalue? I don't...
Well, I don't see that you could,
Right.
where no consideration is coming back the other way.
Well, there is consideration always, because you're paying the debt. That's
Exactly,
not a preference.
exactly.
But where does the jump come to this idea that then it's got to be a transfer of a beneficial interest? Where does that jump come in?
I think what it's said is that it's really my friend's case,
Yes.
but I think what is said is that on the Court of Appeal's decision, one now can treat a corporate transfer as being a 423 from the perspective of the debtor's creditors, because you've not got a transfer of a beneficially owned asset as a requirement. And I think it's said, well, if you have to keep them, if you're intending to keep them separate, that payment from company to creditor at corporate level might amount to a preference, but be treated at an undervalue, and I'll explain why it says undervalue, for 423 purposes at the debtor level. Now, we would make sort of various points on this.
I'm not following
I think the
what's
point
being
of this,
postulated.
that, well, I mean, I'm only trying to grapple
I
with
see,
the
it's
case
a sort of
of
shadow
not my
boxing.
case. Yes, it's much easier when you see the punches coming. But if we take, I think the concern is this, that the transfer from the corporate entity to the other party might amount to a preference. But on the Court of Appeal's decision, the door is open to the possibility that what's gone on is a 423 transaction from the debtor's creditor's perspective. And how does he get the undervalue point? Because, as my Lord says, if it's a preference, then the payment over to the party is extinguishing the debt. He says, unless the money or the debt that's extinguished is one owed to the debtor, then what one has is no consideration coming back to the debtor in that scenario, and therefore it's a transaction at an undervalue from the debtor's perspective. Now, our answer to that is, well, if that was a good answer on that case, it would be a good answer on all cases, because you're ignoring the close relationship between the value of the asset, the property that's owned by the company, and the debtor's shares in the company. And that goes up and down relative to the transfer.
I'm sorry, I'm lost.
Right.
So if we could spell it, I don't
My
know
Lord,
what...
you might just be joining me in the woods.
Well, certainly I'm in the same position as Lord Richards.
Well, I think this is what you said, that if, looking at the other way around, suppose a company makes a preference. The shareholder causes the company to pay off the debt that it's owed. It owes a debt of £1,000 to A. The company, at the instigation of the shareholder, pays off that debt. That might be a preference. It's not at an undervalue so far as the company is concerned, because it extinguishes the company's liability to A. But no consideration moves to the shareholder debtor other than just instigating the payment, and whether that's consideration or not. So even a preference which is at full value as far as the company is concerned doesn't mean that the debtor, who is the person who has to receive the consideration under Section 423, he doesn't receive any consideration because it's not his.
I'm sorry.
asset.
Again, if we, I mean, is my lady's example of what the one you are seeking to address?
Yeah,
the cases that I'm being asked to leave.
423(1) says that it provides that the transaction, which in this case is the payment of the debt for full value by the company to its creditor, is on terms that provide him, the debtor, to receive no consideration because the consideration all goes to the company. Is that the point?
If I sort of begin with saying it's not my point.
No, maybe the best point.
But my understanding is that there's part of my friend's case, and he has a chance to deal with it in his reply, but as part of his case, he refuses to accept that what happens at the company level in terms of the asset has a bearing on the value of the shares being a relevant consideration.
I see where
Now we say it would be balmy if one accepts the Court of Appeal's decision that you ignore the economic impact of what the debtor is doing and deliberately doing via the corporate entity to infringe the interests of his creditors. In the examples from this morning, that would be getting Pipewell beforehand to get rid of its properties in order to defeat the inevitable attempt to get a charging order and go through the process against those properties. So we say that it's relevant to take into account its impact down the line. And this has a very direct impact.
So where's this fitting in with preferences, which is where we were?
Well, I believe it's said, well, if the first payment is a corporate preference...
So let's just give me the factual scenario again.
Well, I'll do my best, my lord, but
yes,
you know...
Yes, but
just take it to the...
Just give me the
materials,
facts, as it were. Yes.
Corporate transfer...
So Company A...
Company A pays off a creditor.
Pays off its own creditor.
Its own creditor. So as between them, that might amount, depending on twilight zones, to a preference.
Yes.
For full value.
For full value. Let's just say full value. I understand my friend to say that must be, if the Court of Appeal's decision correct, a transaction of undervalue.
Can't possibly be. I mean, I do not understand that.
But I think it's because the shareholder has instigated the company to pay off, and what the subsection 1 requires, A, is that he personally has received no consideration. It's only the company that's received the consideration.
Yes.
I'm sorry. Then, so it's not simply that Company A has paid a debt. You're introducing some arrangement between the owner of Company A that he will procure Company A to pay the debt.
Yes.
But that won't involve a diminution in the value of Company A, because the debt owed by Company A is a genuine debt.
Well, it doesn't matter, though, because it's
I think that's your point.
That's my point.
Your point is that if it's the payment of a genuine debt, the balance sheet of the company doesn't change, and the share value doesn't change.
I think the point made against me, and I'm hesitating to try and do this now because I seem to get the backlash for trying to do it. But I believe it said that if it doesn't go directly to the debtor, then it is automatically considered to be a transaction of undervalue. And that's what's being at the debtor level. That's what is said by my friend.
If it doesn't go to
the person inducing Company A to pay the debt.
Yeah.
The person inducing Company A to pay the debt has got to be, yes, a debtor to somebody else.
Yes.
And but if it's at full value, as you say, it doesn't make any difference to the value of the company or to the shares.
But it makes a difference to the... Well, no, it doesn't make a difference to the value of his shares, but it's still on the wording of 1A, a transaction that you're saying he has entered into, the overall arrangement, and he doesn't get any consideration. He doesn't provide any consideration, he doesn't get any consideration.
But where's the undervalue?
Sorry?
Where's the undervalue, my lady?
But 1A doesn't mention undervalue.
It depends whether you look at the arrangement as between the debtor, shareholder, and the person who receives the debt. In that arrangement, the shareholder debtor doesn't receive any consideration for the act of procuring. Does that fall within section 4231?
Where he, just say that again,
So
sir.
the shareholder debtor provides a service, that is, he procures the company to pay
Yes,
the company's creditor.
yes.
He obtains no value, no consideration for carrying out that valuable task. Is that an arrangement that falls within section 4231?
We addressed in our written case that a gift can be made without the giver, without the person affecting it having the beneficial ownership of the asset that's being gifted.
Yes.
So that would fall 4231A, because it's the way my friend Mr. Delante's pleaded cases as well.
This isn't a gift. I mean, what my lord has put to you does not involve a gift.
It's for the services of procuring something. He receives no consideration.
And all that's happened is that we've paid off an actual debt.
Well, you've procured. I think the example
A
being
corporate
put
debt.
is the shareholder has procured the company to pay a debt pursuant to an arrangement between the shareholder and the creditor. Does that fall within 4231A? That's the question.
If the third party gives full value.
Well, it's just the payment of a debt.
I'm struggling,
100 is paid.
I'm struggling to see where the impact on the debtors' creditors' interests arise from.
Then you may say, well, they're unlikely to have got the purpose in 4233, but the question at the moment is whether, nonetheless, because the shareholder receives no consideration, it looks as if it falls within 1A, and that, as I understand it, is why the appellants say the requirement that he is expected to receive consideration means that he can't be treated as one with the company, because he's not receiving the consideration, it's the company that receives the consideration.
Say that there is the reflection of the consideration received by the company on the value of the shares. In this case of a full payment, it would be a neutral impact. If it was less than full payment, it would be...
I think the point I think that Lady Rose is making is that there may be a neutral impact on the value of the shares, but nothing has been paid for the service of procuring under the arrangement. So therefore, does it technically, or does it actually come within 4231A, and then you have to rely on 4232 and 4233 to exclude the making of any order against the procurer, because the transaction has nothing to do with putting assets beyond the reach of a person or prejudicing the interests of the procurer's creditors.
Yes, I mean, certainly, it's not a situation that arises, as I understand it, on our case.
But it could. I mean, suppose one of the sons had just said to his father, I really want to live in 9 Hyde Park with my family. Can you sell it to me? I'll give you what it's worth, however much it's worth. And the father says, all right, well, I'll get the marquee or whatever it is to sell you the house. And the son pays what it's worth. The father has not received any consideration as a result of that transaction.
Be acting like an estate agent. and he would like to be paid for his services.
Estate agents usually.
Yeah, that's right.
Well, let's assume that how many times you would expect to be paid. I mean, I think that's the point, that technically, whatever that means in this context, it seems to fall in 4231A, and that's why they say the fact that it seems to contemplate that he, the debtor, must receive some consideration implies that he must be transferring something which he owns legally or beneficially.
Well, or the consideration being that the arrangement is something that the debtor wants to happen and gets effect into place.
Yeah.
He wants it to happen. He's brought it about. It is him who is behind the transaction with the transferee or the creditor being paid off.
I mean, it would be very, very odd if the example given fell within 4231A, even ignoring 4233, I would suggest. Because after all, if the sale is to be at full value, then that's something that the seller will want to achieve as much as the purchaser, one assumes.
Well, you may get there by saying the term, what we're dealing here is defining what's a transaction entered into at an undervalue, and here there's no actual undervalue. So
because it's an agreement to procure something in circumstances where you would not expect consideration to be paid. So, I mean, there might be very special circumstances where you did, but the effect of the shareholder requiring an extra payment is actually that the purchaser has to pay more than the market value. I mean, it's likewise really with the shareholder agreeing to procure his company to pay the debt. All the shareholder is doing is getting his company to do what it should be doing anyway, which is to pay the debt. It's just not. It's not as if he is putting the funds into the company to enable it to pay the debt. That would be a different situation. I mean, it just would seem extraordinary that anyone would suggest there was that any consideration should be payable for this undertaking. As my lady says, it's just simply not a transaction at an undervalue in those circumstances.
Yes.
So it just wouldn't come within subsection 1.
Certainly, I mean, we would look at it because very much part of our case is the reflection of what happens at the corporate level, at the shareholder level, because and if that's what the transaction is all about and intended to achieve, which is the impact at the shareholder level, on an example as my Lord Richards has given, there is no negative impact at the shareholder level because the preference payment at the corporate level has paid off a liability of the company. So it's value neutral and doesn't result in the shareholders' creditors having their interest prejudiced. Whereas if it's undervalued at the top, it does.
Procuring, therefore, has to be seen in the context of a situation where you would expect to be paid in accordance with common market values. And that would also apply to a situation where a debtor's son induces his father to pass the estate to his grandchildren. You wouldn't expect to be paid in such situations. So it's not a transaction at an undervalue.
No, and I think my Lord Richard...
An estate agent would expect to be paid if it arranged a sale, procured a sale,
yes,
procured a purchase.
Yes, yeah. And the elderly father example, I think my Lord Richards drew a distinction which we would agree with between that factual example and a debtor who controls the company. Because at some point you are, in the elderly father example, you are seeking to persuade and influence their own decision-making, a free choice by the father as to what he does with the will. Whereas with the company, you are the driving force behind it because you have control over it. So it's not a question that you're going to come up against a contrary will that needs to be suborned.
Right, so, but the elderly father being persuaded to change his will is only a problem for you if you were trying to extend the reach of this to directors who were influencing the shareholders to do something. But you're not, as I understand it.
No.
And that may bring us to Feakins then.
No, we're not in that territory, my lady. Just moving on, if I may, to very briefly, Clarkson and Clarkson. I've trailed some of what I wanted to say about this yesterday, which is sort of standing back from the details and looking at the case. We say we don't accept that it can do the heavy lifting that my friend needs it to do, which is that it stands as authority that a 423 claim must involve the transfer of a beneficially owned asset. It was a 339 claim and discussed in specific factual context. Lord Justice Hoffman in the Court of Appeal was not asked to consider the wider ramifications of Section 339, the implications of its decision in other provisions, including Section 423. Indeed, he wasn't really asked to consider, at all the relationship between 339, 238 and 423, nor anything to do with preferences. And we ventured to suggest he wasn't intending to lay down any specific rule or ratio as regards 423 or Section 238. And in confining the case, as we say it should, to a case on 283, we're in the company of Lord Collins in TMS and Merrill Lynch, as we set out in our written case at paragraph 99, 187.
So page number, sorry?
It's paragraph 99, page 187.
Thank you.
And obviously the appellants themselves, as you've seen already in my submissions, when their case was fixed to Section 283, seemed content to read Clarkson as a 283 case and nothing broader than that. And the references there are pages 424 and 440, 424 and 440. And the Court of Appeal here reached the same conclusion as to the scope of Clarkson at paragraphs 68 to 73, page 225. So that's 68 to 73 of the Court of Appeal judgment, page 225. And we've searched various texts and what have you to see if it's being cited for any wider propositions. That's not obviously telling, particularly at the level of this court, but it's at least informative that the commentators aren't looking to it to support the proposition that my friend relies on it for. And you'll see those references. I'm not going to go to them. At paragraph 99 of our written case, that's footnote 38, page 187. And at the end of the day, as my Lord Hodges pointed out yesterday, if one really just looks to the end of the case, Lord Justice Hoffman described it as a very simple case at page 1709, and that case that he describes is not one that stands for the ratio that is now being put forward. And as I understand my friend's case, at paragraph 155, page 130 of his written case, paragraph 155, page 130, he uses it to stand for the proposition that unless the claimant can show that the debtor has given away his own property for nothing or at an undervalue, the test isn't satisfied. Prejudice to the interest of creditors which occurs in some other way is not within the scope of the transaction at undervalue test. So it's one that requires the debtor to give away his own property for nothing and undervalue, and we say that that's not the ratio of Clarkson, certainly not as it applies to 423, and it appears that my friend's use of Clarkson is now caveated with, at least in respect of 339, is the way it's often now introduced. I think it's the way it's now put in his written case. But we say that it doesn't and can't do the heavy lifting of a broad proposition that the transactions and undervalue must across the board involve a transfer of a beneficially owned asset. And we would urge caution on the court in accepting an invitation to rely on it or the other arguments for such a broad-based case, when that case has been the subject of a fair bit of variation and movement between the Court of Appeal and here, and that it seems to be part of my friend's understanding of this area of the law that there may be other untested forms of transaction at an undervalue which may not fall within their strict requirements, which I think are identified in paragraphs 220 and 228. It's said that they're not before the court and we're not there to discuss them, but one might sort of be concerned if one's putting a bright line down on the ambit of 423 to know what's supposedly within that line and what is without. So we say that the proposition that my friend began with certain propositions yesterday, that loss alone isn't enough and benefit alone isn't enough, and it needs to be all tied up with a transaction that is limited to the transfer of beneficially owned asset. I understood him to accept that in the corporate transfer where the principal or sole property has been moved, the sort of paradigm example of what we're talking about, that he accepted that there may be loss considered there to the shareholders because the principal asset has been moved, that there are transferees who've obviously benefited by the receipt of the property that has been moved. But what he refused to accept, I think, to my Lady Rose, was that those two couldn't be connected. And we say that's ignoring. This isn't a case simply of loss over here, entirely separate and independent of the value received over there. The loss correlates to, is related to, is determined by, whichever words one wants to use. There is an inextricable connection between the two that performs the necessary transaction, and so that propositions 1, 2, and we say 3, well, 1 and 2 are satisfied, and 3 that they're brought together. They're not needing, there's no need for that last proposition that there must be a transfer of a beneficially owned asset that caused the loss that led to the benefit. So just standing...
You do accept that, I think you probably accept that proposition 1, an act causing a financial loss is not sufficient on its own, is correct, and proposition 2, an act which causes another person to receive something valuable is not sufficient, but you say you don't have to jump to that, from that, to his proposition 3 to say that there must be something that belonged to him that's transferred or given away.
Yes, I mean, it was said yesterday, and it puzzled me, that if propositions 1 and 2 were correct, proposition 3 followed. Your submission is it doesn't.
It doesn't. I mean, on the facts, you can establish the connection between proposition 1 and 2 by accepting on the facts of our case that the shareholder's loss has been caused by the benefit received by the transferee, that they're not entirely separate and distinct. And of course, it's one doesn't just simply look at loss alone and benefits separately. One puts them together And you can see that would there be any difference to the debtor's creditor's interest being prejudiced if the debtor had just simply taken X number of shares and got rid of them? You'd say no. Okay, the number of shares may be less, so the debtor's interests have been impacted. But if the number of shares remain, but each value of the share is reduced, then the creditor's interests are plainly impacted. And the oddity here is the impact, just as a matter of practical reality, is a very direct impact. I'm not here saying that move £1 million absolutely means that the shareholders' interests will reduce by £1 million. I understand that there can be difficult issues. My point is a much more basic one, that by moving the corporate asset, you are moving the only means of the value in the shares. There is a direct connection between the two, which doesn't even exist on my friend's revised case. Because, so there's a direct impact on the assets owned by the debtor by virtue of the dealing with the corporate assets. That direct relationship doesn't actually even exist on the revised case, because on the revised case you have at one end the core primary argument of it must be a transfer of a beneficially owned asset, i.e. what you are doing in this transaction directly impacts a beneficially owned asset of the debtor. That's the primary argument. At the far end of the spectrum, he now is forced to accept, because this doesn't answer everything he needs, he's now forced to accept liability of a contingent nature which may, if enforced, be enforced against the assets of the debtor. That is enough to get 423 going. But, my goodness, not the bit in the middle where you can show that your conduct in dealing with the corporate asset directly impacts the value of your own assets available to the shareholders, to the creditors. At that point, they say no. Even though on a man-in-the-street analysis, on the Clapham Omnibus, we used to say, they would say, well, obviously, if you move the corporate asset, you're taking the only value of the shares. You are impacting directly the assets that are available to the shareholder. On the possible liability which may never arise, and if it arises, may never be imposed on the assets of the creditor, there's many more stages away than our argument, and yet it's rejected on my friend's case. Just factually, we're a lot closer to dealing with the beneficially owned assets on our case than my friend's case on liability is.
But you do accept that it has to be some effect on the value of the shares, and if the assets of the company remain of the same value after the transaction, even if the nature of the assets may make it much more awkward for the creditors to get to, that would not fall within 423?
Yes, my lady, and that's where I would agree with my friend that we depart from the freezing order jurisdiction, yeah, where one would be able to get a freezing order to stop assets being available and being moved abroad in order to make assets more difficult to enforce against, when that doesn't then have a monetary impact on them. Of course, if the movement away had a monetary impact on the value of the assets being dealt with, then there may be an argument. But in principle, your point is that making it more difficult to enforce mean that it is naturally within 423.
Yes, the test for the freezing order includes a likelihood of dissipating the assets. Yes. So I think the assumption is that if they're moved somewhere else, they may then be dissipated.
Yes, it may be more readily available or very easier to dissipate, although it is expressly recognised in the freezing order jurisdiction as a head of dissipation. Odd though it sounds, right, the movement of an asset to a more difficult to enforce jurisdiction, which is why in very rare cases one can get a mandatory moreover to bring it back. I fell into the old language there, I do apologise. My Lords, we dealt with, towards the end of our written case, some of the various propositions that my friend raises, and I wasn't going to spend any real time on them now. I mean, for example, there was the reference to the bona fide defence. We say that in the scenario that we've been talking about, the defence under 4252A, which is available to somebody that doesn't receive directly from the debtor, that would factually be engaged, other things concerned, in a corporate transfer, because you're not receiving directly from the debtor, you're receiving from the company, and that's precisely what that clause is intended to achieve. So we don't think there's anything particularly untoward about that. And secondly, there's a point about presumption about dealing with property rights. If it's suggested that this is that the Court of Appeal's decision unfairly or improperly deals with somebody's right to deal with their own property, we question that analysis because in the corporate transfer example, it isn't a decision by the company to make an ordinary, genuine, good faith commercial payment. It is a decision by the director who controls the company, and therefore every likelihood his intention. He's a shareholder, but he controls the company as a director, or via the directors. His intention, if it's an untoward intention, will be attributed to the company and impact the nature of the transaction that's undertaken. So it's not a situation in which, maybe to bring it back to the elderly father example, we're saying that the company making the payment isn't having an ordinary commercial transaction interfered with. It is a transaction that's being entered into precisely to achieve the purpose of 423. And that is something that can be set against the company dealing with the transaction. But the father being persuaded, etc., that's a different scenario. Here, the transfer that's being interfered with is a corporate transfer that has been brought about and driven by and with the intention of achieving the purpose of the 423. So interfering with that is a good thing as far as we are concerned, and is exactly what 423 is intended to achieve.
Just on the point you mentioned a moment ago, section 4252, do you have any suggestion as to why the distinction is drawn between a person who acquires the property directly from the debtor and the person who does not acquire it directly from the debtor? Because as you rightly say, the defence in 4252 would be available on the facts of this case, but wouldn't be available if the property were transferred by the debtor himself.
My Lord, just simply I think that those who deal directly with somebody involved in the transaction which is immediately impugned are more likely to be considered involved in that underlying transaction. I am recalling Mr. Justice Millett in I think it was Argy, and the attempts to explain away why the initial recipient isn't or couldn't be liable for knowing receipt, because it was and he should be treated differently from a subsequent recipient, because further away from the original impugned transaction, you've got assets that are being transferred, and we have. I'm trying to work out why they might do it. We have the security of holding assets and not interfering with assets, so that when one moves further away, one wishes the recipient to be more secure in their receipt.
So that was a reference to which authority you mentioned just then?
I'm from recollection, I believe it's Argy.
Oh yes,
Mr.
yes.
Justice Millett and Argy, and quite a bit of a mess he got himself into, with greatest respect, as to initial and subsequent recipients. I see Professor Virgo's smiling at that point. He'll know more about this than I.
It was certainly a decision that prompted a good deal of writing.
Yes, I think it may also be the decision that talks about a stream of electrons when we're talking about bank transfers. I need to go back to that point.
It's because you're dealing, people who deal directly with the debtor are.
Yes, a decision's been taken to treat them differently.
They're involved in the dealing, in the transaction in some way.
And others are further away from the culture.
So if the sons are told by their father, you're going to get this house which belongs to a company in my control, they are in some way, and they assent to that, and the property's put in their name, they're involved in the arrangement.
Yes. They're just closer to the coalface.
Closer to the, yeah.
I mean, they may still be in good faith. They may have no idea about the litigation or the threat of litigation.
Yes.
So applying it to the facts or the presumed facts of this case, the bona fide purchaser defence would not be available to the sons.
My understanding that all of the claims involve allegations of, can I put it back to the kitchen table?
Yes, well,
all of the claims involve that.
But assume for one moment that we haven't got any kitchen tables. What you say is the effect of 2A on the facts of this case?
Well, I think your whole case is that no value was given.
There's only one case, as I understand, one allegation.
Yes, no value. Yeah.
Where we're outside of 4231A.
But I think you would accept that they are, because the company is interposed between them and
Yes.
and you accept that they are acquiring the interest in the property from a person other than the debtor.
Yes, we do accept that.
So they wouldn't fall at that hurdle of the being able to establish the defence. But they, you say, definitely fall at the for value hurdle, and in the kitchen table scenario they may fall at the without notice of the relevant circumstances.
Yes, my lady. My lords, my lady, that's what I wanted to say. I've been able to finish a little bit early because I was going to deal with self-dealing fallacy at one point, but those notes were blissfully chucked away last night after our conversation.
I just raise one point? It just goes back to when you were making submissions earlier this morning about remedies, and you pointed out correctly that section 423, I think it is discretionary in the sense that the court may, that's right, subsection 2, make such order as it thinks fit. So the point is made by the appellants that in the equivalent provisions of sections 238 and 339, the word must is used. I had at the back of my mind, I'm afraid I've been unable to dredge it up, assuming it exists, authorities on must, if it thinks fit, actually giving the court the same discretion as it would have under may. Are you able to help me with those?
Your Lordships, not with the name of the case, but I can certainly confirm that was our understanding as well, that both were treated as discretionary, notwithstanding the difference in the terminology.
If you're able to, your junior or those behind you, able to find such authorities on that as exists, I'd be very grateful.
Yes. I think it must have been mentioned in one of our written cases at some point.
I see. Oh, I missed it.
I hope anyway. But my Lord, we'll definitely deal with that point. But your recollection is the same as mine on that point, that they're both treated as discretionary.
One point I think which was made in the appellant's case was there was no definition of the nature of the control which the debtor had to have over the company, in contrast with the statutory provision helping to define an associate in section 43510. Do you have anything to say about that?
Why would we?
Pardon?
Why would we have a definition of control in a provision like 423? You need it in the other provisions because associate and connected parties are an important part of the automatic trigger of the application of sections 238 and 339. There's nothing automatic about 423. It's a deliberately a discretionary regime to give the court the ability to meet the difficulties that fall within the targeted mischief. If I were to have control properly defined, this number of shares, what have you, or what have, then I can tell you now in the Provence conferences of drafters of these arrangements, they would say, oh look, there's a criteria that we just need to get outside of. We'll draft accordingly. You don't do that. You don't tell a fraudster or somebody that's going to behave in a manner that falls within 423. You don't tell them precisely what they shouldn't do and give them an ability to move around. So that would be my short answer.
That was the answer I was expecting you to give. Thank you.
My Lord, and just one thing on the...
As far as, I mean, even if you only held 10% of the company and it was a big company and those shares were actually worth a great deal of money, if you were able to influence the company to do something which significantly reduced the value of your shares, and you did it with a purpose, there's no reason particularly why you shouldn't be caught just because you've got a minority.
No, but I mean, obviously that's not our scenario, and I don't need to go that far. And in those circumstances, there may be other natural bars to preventing such conduct, like the other 90% of the shareholders, because presumably whatever conduct was being envisaged by the individual 10% holder to devalue the shares is going to devalue the other 90%. And just practically, it's unlikely they're going to sit back and allow that to happen. And they have the ability to control it by virtue of the 90% with a common aim to control such conduct. And then on anything else, where one then gets into higher figures and what have you, that really is out in the wash for the remedy side of things. But I just wanted to do was one phrase that I didn't get in, and I'm quite keen to get in from the Court of Appeal's judgment, and that is in respect of the description of Section 423. They characterise it as a discretionary judicial regime, paragraph 99, page 230. And that really is the short and clear answers to why, to my Lord Hodges' question, you wouldn't have a bright line on control to reduce that usefulness.
So that distinguishes it from the Fisher case, which is referred to.
Absolutely, and your ladyship will recall that even in that case, which is different, and there's tax and all of those different connotations, your ladyship made a point about you would be less concerned if the statutory defence or the statutory offence required the motive of each individual taxpayer entering into it, so that the good guys and girls could be distinguished from the bad, rather than they're all being grouped together. And of course, Section 423 does precisely that, because those other shareholders that might be dragged along can't be said that they're engaged in a 423. They're not, one, controlling the scenario, and two, engaging in it, driving it forward to carry out the 423 purpose. My Lord, that was what I wanted to say, and I finished a little bit earlier. I'm in your hands as to whether Mr. Delahunty rises now or whether we take an early lunch and come back. There's no danger of us overrunning our time at all. And you wouldn't allow it anyway.
I wouldn't allow it. Well, Mr. Delahanty, are you in a position to commence now? Or let's press on. Thank you.
My Lords, my Lady, it is conventional at the outset of submissions to tell the Court what I propose to speak about, but I actually, if I may, just begin by telling the Court what I do not propose to speak about. I'm not going to address the Court about leases, about powers of appointment, forgive me, any more about sons and their inheritances, or any of the myriad hypotheticals which my learned friend postulates. I want to address directly the position of debtors who own companies, which companies in turn own valuable assets, which assets are transferred away, having been procured by the company, having been procured to do so by the debtor. And in that regard, I want to introduce the Court to the one case decided after trial in England where 423 relief was granted in precisely those circumstances, which is on all fours with the case we have here. And that is the case of Akhmedova and Akhmedov. And it's at page 834 of the bundle. So the Akhmedova decision is a first instance judgment, but it is something of a case study in attempts to defeat creditors. It's illustrative of the real world mischief that creditors are faced with and that courts are faced with when unpicking these transactions. It really serves to demonstrate and highlight the protective purpose of 423 and how it's undermined by the appellant's interpretation. I'm going to invite the Court to draw 4 insights from Akhmedova. Not propositions of law, just insights. The first will be as to the purpose of Section 423, to address my Lord Stephen's queries of yesterday. The second insight will be as to the significance of the wide wording of Section 423, and I'll invite the Court to engage in a compare and contrast exercise with Section 37 of the Matrimonial Causes Act 1973, which was also addressed in Akhmedova. Third insight will be as to the practical enforcement steps that a creditor might wish to take against corporate assets, and how they were frustrated in this case, addressing Lady Rose's queries and putting a practical edge to what my learned leader had addressed you with this morning. And the fourth insight in the case will be as to how the facts in this case starkly show, vividly illustrate the policy concerns which underline 423 and why 423 relief was granted in that case. So, before diving into those 4, the facts of the case. So we had a husband who was a judgment debtor of his ex-wife to the tune of some £453 million under an English family court judgment. And he either made or procured a series of transfers of assets, some directly by his own acts, some via companies he controlled, and in respect of some of those where the corporates were involved, they were either beneficial, some were beneficially owned by him, the corporate entity was just a nominee, and some of them were like we have here, and this will be the key example, a situation where the corporate entity itself owned fully, legally and beneficially the assets. That latter category, which is of interest to us, concerns a Moscow property. And if I can ask the court, or maybe for your reference, at page 907 of the bundle, we have a very helpful glossary which makes sense of the various web of entities and individuals involved. Your lordships, my lady, you'll note there's copious references to Liechtenstein and Panama and all such other exotic places in this glossary. But at page 907, about halfway down the page, 905, starting at the bottom, the asset with value, you see Moscow property.
Moscow property.
Moscow property. So this is, it's 905 of the bundle, my lady. It should be a glossary table. So we see Moscow property. This is at 9 Solyanka Street, Moscow. And then at page 907, moving up the structure, we see halfway down the page, or 2/3 of the way down the page, Solyanka Service, which is a Russian holding company which owns the freehold to the Moscow property. And then up the chain, but down the table, Sunningdale Limited. And that is a Cypriot company owned by the husband, described as the indirect owner of the Moscow property, but the basis for that is that it holds 100% of the shares in Solyanka Service. So we have a situation, albeit there's an extra corporate layer involved, where you have real estate, and the value of the shareholding, or the real estate, the value of it is reflected in the value of a shareholding all the way up. And in this case, the transaction which is challenged is the transfer.
Sorry, did you say that the husband owned
it, Sunningdale? Yes, and that's helpfully there in the.
Yes, so the husband owns 100% of Sunningdale, which owns all the shares in Solyanka Service, which is the legal and beneficial owner of the Moscow property.
Exactly, exactly so. And the transaction which is challenged is the transfer by Sunningdale of the shares in the Russian holding company to the son, which transfer was procured by the husband. So this to
no value, presumably.
For no value. Well, there's an issue. It was either undervalue or value, but it's a question of whether there was illusory promises to pay made, which needn't detain us. But
I'm sorry, could you just repeat that again? I was distracted by something. So the transaction which is challenged, is the transaction
of the transfer by Sunningdale of the shares in the Russian company Solyanka to the husband's son, which was procured. The transfer by Sunningdale was procured by the husband. Yeah. And we can see that procuring, let's start with the act of transfer. It was at para 69 of this judgment, which is at page 847. And that's just for your lordship's reference, that's what I've just described. And there's also reference in similar terms at page 200 and to paragraph 289 and following, and that's at page 887.
Sorry, the page number again, sorry?
887.
Thank you very much indeed. Thank you.
And it's referred to throughout this judgment as the Moscow property transaction. And in terms of the husband dealing or being involved and therefore party to this transaction, we can see that at page 889 of the bundle, which is paragraph 308. And it's worth, actually, I'll read this, my lords. Standing back, looking at this transaction in the round, the transfer of the Moscow property happened because the husband said it should happen, and his representatives then implemented those instructions. So that's what happened, and the relief which was claimed was the transfer of the primary relief was transfer of the Russian shares to the wife. So the shares just directly to the judgment creditor, reflecting the broad discretion, and alternatively to pay the value of the Moscow property to the wife. And that was the recipient who would be paying that. That would be the son who would have to pay that. So that's the shape of Akhmedova. And to take your ladyship's phrase from yesterday, this maps across in a way that it's very difficult to see, to navigate mapping across Clarkson or mapping across Feekins, but this case maps across. So, my lords, the first insight, which I may just highlight before the court rises, is just, if I can ask your lordships to turn up page 893 of the bundle. And this, under the section heading Relief, what we get is the analysis from Mrs. Justice Gwyneth Knowles about why Section 423 is engaged. And we can see at paragraph 329, she describes what I've described in the first part of that paragraph, the transaction which was happening. And she notes the very wide wording, I'll come to that in my second insight, about Section 423. By reference to what a transaction can constitute, that is to say, more than the act of transfer. This is my Lord Stephen's point about procuring somebody to do something can be make you a party to a transaction. But then in the second part of this, it's where she says, her ladyship says, Section 423 is engaged because the husband, as a person, arranged the transfer of Sunningdale's shares in Solyanka Service, which is a transaction for the prohibited purpose. And this comes down to the insight, the purpose of Section 423. This reading of Section 423 is plainly correct. Otherwise, the protective purpose of the statute could easily be sidestepped by a sophisticated debtor simply causing companies he owned to transfer their assets away. And that is what, so when my Lord Stevens asked my learned friend, well, where is the restriction, or well, what is the purpose? And it was said to be transferring of beneficial interests away. That wasn't tethered to any language as to why what is a protective purpose of Section 423 should be constrained. And that's what we get from this case is, or from this passage, is that her ladyship is looking at a circumstance where value is extracted from a company and recognises that in order to protect the interests of those creditors, it is the role of 423 to step in. Just as we rise, my lords, I'll give two cross-references.
Well, 330 is an important paragraph as well, isn't it?
Yeah, now that is the third insight, but it's on the list for maybe ascending order actually, but certainly your ladyship is ahead of me. I was only going to give two references to the recognition by her ladyship that what was an interest and what needed to be protected was the value of the Moscow property rather than simply the interest in it, and those are at paragraph 69 of the judgment, and that's at page 848. There's a reference to the transaction being for the purpose of putting the value of the Moscow property beyond the wife's reach, and similarly, there's a similar reference in similar terms at paragraph 309, which is at page 890. And again, it's referring to why she is a victim. It was a victim because she could no longer, the wife, realize the value of the Moscow property by enforcing against the shares.
I suspect if it said realize the Moscow property, it wouldn't have meant anything different.
Well, it might not, but it just shows the focus. It shows the focus of the court on what it is that's being protected from the creditor's perspective. She
doesn't want to go and live in the Moscow property.
There are photographs on Google Maps. It's actually not such a bad place.
Is that a convenient place for us to adjourn? Thank you very much.